Right, folks, thanks for coming today. We're going to talk about the Supreme Court and what their role is. We're going to review some of the controversial rulings. We're going to talk about what's happened due to the kinds of rulings they've been making in terms of their own internal dissension, confusion throughout the judiciary, loss of respect by the public, and what we can do. And of course, there's always a call to action. So the first thing we want to talk about is what the role of the court is supposed to be under our constitutional system. And I want you to keep this stuff in mind as we're going through the presentation, because I think we're going to find that they are overstepping the role they're supposed to have in our Constitution. Final arbiter of law. So if some law is not being implemented properly, according to what Congress meant, they're supposed to make sure that laws are implemented the way Congress meant them to be implemented. And they're supposed to guard the Constitution to make sure that all the intent of the Constitution is undertaken, protecting our civil rights, our liberties, maintaining checks and balances to ensure that one branch of government, the administration or the Congress, doesn't overcome the other two, which is kind of weird because I'm going to be claiming that the third branch of government is overcoming the other two. So it's not so much that they're maintaining checks and balances, but perhaps we're substituting themselves for it. There are certain federal cases that they and only they are supposed to adjudicate, and they're supposed to ensure that our broad provisions are properly interpreted over for our times, so that our document is a living constitution. And a lot of people will say, well, we're not really doing that. Let's look over some controversial rulings. There's some rulings about how federal agencies, their power will be reduced by their actions and judicial oversight increased. There's the overturning of the Chevron doctrine is right along those lines, where we used to give deference to federal agencies in interpreting ambiguous statutes. And now the court says, no, the administration can't interpret ambiguous statutes. The court will do it. And there's rulings since Bruen, which Bruen greatly confused the gun violence prevention area, and there have been some recent rulings there. And of course, there's all the rulings involving former President Trump in terms of the 14th Amendment, in terms of immunity. And the rulings we've seen here are restructuring the federal government dramatically since the most dramatic change since the New Deal, with long-term implications that we'll get into. Let me start by talking about a securities fraud ruling. There was a process in place where the SEC could use civil penalties through an in-house court, so to speak, without having to go through the real judiciary. Then the fraud cases now can't be handled internally by the SEC. They have to go to the federal court. And that makes it more difficult for SEC to enforce their requirements. The government had argued that SEC fraud cases involve public rights that can be resolved outside of an Article III court without a jury. And we've been doing this for a long time. So it's kind of a narrow ruling, but it does impact the SEC's ability to protect our rights in the free market, and it's part of a broader trend. In summary, the court has mandated that SEC must prove securities fraud allegations to a jury in a federal court rather than doing it internally, and that will constrain SEC enforcement. In 1990, Congress passed a bill called the Penny Stock Reform Act, which allowed the SEC to do the stuff in-house. Congress wanted to give the SEC the power to do the stuff in-house without taking out to a real court. And in 2010, Dodd-Frank expanded those capabilities. Congress clearly wanted the SEC to be able to implement its authority without going through the complete judiciary. Well, SCOTUS has decided that Congress was wrong. After 35 years, it doesn't matter to SCOTUS what the intent of Congress is. SCOTUS is going to decide for themselves whether we can do this or not. So that's just one example of a 35-year precedent, which is upheld by all the courts before this, which has been dismantled by this court. There's another ruling along the same lines about statute of limitations. Prior to statute of limitations started when a regulation was issued. If a regulation is issued, you got 6 years to contest it, to discuss it, bring it up in court. After 6 years, statute of limitations expires, and it can no longer be challenged. Now, the court has held that it's not 6 years from when the regulation was published, but it's 6 years from when you find that it affects you, which means that the regulations are never finalized, which means that somebody can always come up with a new case saying, this regulation now affects me. And then he's got another 6 years to pursue it in court. There was a dissent from Justice Brown Jackson who warning that this wipes out any sense of finality in our rulemaking, opens the door for perpetual challenges to every federal regulation, and it significantly expands the pool of potential plaintiffs in the time for them to challenge our regulations. So once again, a very long-standing precedent, which has served us well for decades, has been reversed. This was in place since 1946, and now regulations can be challenged decades after they've come into effect. It greatly increases the uncertainty about our government. 80 years worth of precedent have been discarded by this court. Chevron ruling is another significant area. What the Chevron ruling used to say was that if Congress passed something that's a little ambiguous, the administration, who has experts in the field as part of their regulatory organization, can clarify what Congress meant, so that any ambiguities, the experts in the administration are presumed to understand the best way to clarify those ambiguities. And the Supreme Court has now said, no, the administration can't be presumed to clarify regulation. Either Congress is specific in what they want, or the court will decide what they wanted, which shifts a lot of things, a lot of power from the administration to the court, and means that agencies are not so clear in what they can and can't do. It will increase litigation. It might require Congress to become experts in many areas where they are not now experts. It increases judicial power. So the Supreme Court's decision to overturn Chevron just moves power from Congress and the administration to the courts, eliminates the requirement for the courts to defer to agency implementations. Now, Congress often passes bills with very general statements of intent without detailed, specific statements about implementation. They leave it to the administration to figure out exactly how to implement the will of Congress. And the administration has experts in the field to determine how to best implement the will of Congress. At the EPA, at HHS, at Homeland Security, et cetera. We've been doing this for 40 years. So now the court says, no, either Congress has got to be really specific what they want. The administration can't interpret it for Congress. And if there's any interpretation to be done, we'll do it in court, not you. Court has no expertise in these areas. All the court can do is bring in the experts from the administration, bring in the experts from people that are contesting. So you might very well end up with the same result if the court believes the experts in the administration, but it won't be as easy. It'll involve a lot more work and court appearances, and Congress is not equipped to take on this role. And certainly, technically nor politically, is Congress able to produce specifically detailed legislation. Let's talk about gun violence prevention. Back when they issued the Bruen recommendation, the Bruen decision, they struck down a concealed carry permit as unconstitutional. And they said that the Second Amendment protects the rights to carry weapons, and that laws requiring special needs are unconstitutional because they said that there were no laws like this historically in this country. They were saying that that you have to have some tests focus on the text of the Constitution and the history of how our country has interpreted the Constitution. The Bruen decision said the government must justify the regulation by demonstrating it's consistent with our nation's historical tradition. And that created a bunch of problems for us back when that was put out. Ruling created confusion in the lower courts. It prompted challenges to all kinds of gun regulations. States have had to pass new laws designating sensitive places where guns cannot be carried, but those also face challenges. prosecutors are facing difficulties in enforcing existing gun laws. Overall, Bruin has significantly weakened states' rights, states' ability to regulate firearms, has set the stage for further legal battles. For example, with Bruin, it's basically saying you can't regulate firearms more stringently than we did in the past. For example, in the past, spousal abuse was not a reason to take guns away from somebody. So we can't do it now. And that's how many lower courts interpreted what the Bruin decision means. And many lower courts struck down red flag laws based on the Bruin decision. Well, in this session, Congress went back and looked at some of those. And SOTUS clarified Bruin by saying, no, we didn't mean that you have to strike down red flag laws. Well, I mean, that's good. But it just shows how confusing the landscape has become because of their choices, their decisions. The lower court said, no, we won't have to specify exact replicas of historic law, but it's enough to be in the ballpark. And they said if an individual poses a clear threat, he can be disarmed. The laws don't have to be identical to the past. They have to be at least somewhat consistent. It said the lower courts misunderstood what they meant. But Justice Brown Jackson said it's the high court's responsibility to make clear what they mean to the lower courts instead of saying something so vague that lower courts can misinterpret it. So even Justice Barrett, who's conservative, has raised concerns about Supreme Court's approach to basing our current laws on history. She said that imposing a test that demands overly specific analogs to past laws is a serious problem. It forces 21st century regulation to follow late 18th century political choices, which gives us a law trapped in amber. And of course, Roberts says, well, that's not what we meant, but clearly that's what the lower courts took from their statement. And gun regulations are still a big mess. So the decision I just talked about that clarified the red flag laws can stay. The lower courts still lack comprehensive guidance. There's confusion. There's divergent implementations. There's methodological questions. There's ongoing legal challenges. There's political influence. There's the Bruin decision, and this clarification still leaves us with a total mess in terms of how we implement gun regulation. It all started all the way back with Heller, that created an individual right to own a weapon out of whole cloth when the founders never intended that. All the way up through Bruin and through today, SCOTUS is reinterpreting our Constitution in a haphazard manner. They're establishing policies our Constitution and founders never intended. They're wreaking havoc on our lower courts and our country, and they've complicated our efforts to have a civilized country. They're just blundering around. It's like a bull in a china shop, these idiots. Now let's talk about the 14th Amendment. Part of that amendment says if you're a traitor, you can't run for office. Well, most legal scholars believe that provision is self-executing, just like this thing that says in the Constitution you got to be native-born citizen, you got to be 35 years of old. There's no legislation enforcing those things. States just enforce them because that's what the Constitution says. And most legal scholars believe that the part of the 14th Amendment that says you can't be a traitor is also self-implementing. And existing states have always implemented those limitations themselves. Supreme Court ruling, what they ruled is that the 14th Amendment cannot be implemented by states themselves the way the other limits can. And that's weird because the intent of the Constitution, the intent of the 14th Amendment is clear. The judicial interpretation basically says, we believe Congress has got to do this, not the states. But Congress isn't involved in any other of those limitations. But I know some people say the 14th Amendment has a clause that says Congress may implement legislation. But it doesn't say Congress must. It says they may. It doesn't say they have to. And it doesn't say that these portions don't work if Congress doesn't. So in summary, the intent of the Constitution is clear. The Supreme Court just decided we're not going to follow the intent of the Constitution because they felt that allowing states to implement these parts would lead to frivolous attempts at kicking somebody off the ballot. So the Supreme Court decided by themselves, we're just not going to follow this part of the Constitution. That's not upholding a Constitution. It's deciding not to uphold it. And now let's talk about the presidential amnesty ruling. So now the Supreme Court says that the president has broad immunity from prosecution for for official actions taken. They conclude that the president's authority in certain areas must have immunity for the president to feel free to act when he needs to act. And the point is that the majority argues that the Constitution's silence on the issue of immunity is not the last word, and that the framers must have known that immunity was necessary, even though they didn't write it down. The dissenting justices says, "What are you talking about? If they meant it, they would have written it down." And establishing a precedent that allows the president to be able to the law is dangerous. So now there's some debate. The majority argues that the president's exclusive powers must be protected. The dissent continues that the Constitution doesn't protect it. So you might want it protected, but saying the Constitution protects it doesn't mean it does. The Constitution provides no basis for president's immunity. SCOTUS, by themselves, decided it would be a good idea, and that they needed to do it so the president could do what he needed to do. So now, heck, the president could take a bribe to appoint an ambassador or grant a pardon. We can't even investigate it. They've even limited what we can call as evidence. Now, here's some late-breaking news. You all know, I think, that Judge Cannon has dropped the charges in the documents case against Trump. And I want to make it clear exactly why that happened. You see, back in the immunity case, Judge Thomas, in a concurring opinion, added some extra stuff. He said in this concurring opinion, and by the way, I don't think Jack Smith's appointment is constitutional. Well, that had nothing to do with the case at hand, but he went out and said, I don't think Thomas's appointment is constitutional. I think we should have a lower court bring a case where we can decide that. He said that there's no congressional authorization, that there's no appointments clause. Appointments clause doesn't talk about this. There's no historical precedent. Well, there is a precedent, but he kind of ignored it. He's challenging the longstanding practice of appointing special counsels. And he thought of the separation of powers issue. So what happened here is Thomas strayed from the topic at hand to give this view. He raised his concerns, which had nothing to do with the case we were talking about. They weren't directly germane to the issue. He went beyond the scope of the immunity question to question the constitutionality of a special counsel. And he suggested that there are serious questions and they weren't material germane to what they were supposed to describe. And Judge Cannon just latched onto that and said, okay, I'll go with that, Justice Thomas. I'll kick this case out based on what you just said. So what happened here is Thomas threw out a lifeline to Trump, and Cannon picked it up and used that lifeline. She quoted Thomas's opinion 3 times in her decision. Now, we've been using independent counsel since Watergate. Congress had legislation to authorize independent counsels. It expired in 1990, and the administration has continued to practice since then under their own regulations. And there's an interesting story to that I just learned after I made the slides. I didn't put on the slide, but here's the interesting part. When Congress saw the independent counsel legislation was going to expire, they hired a team of constitutional experts to decide what to do about it. And the team said, you don't need a law here. DOJ already has all the power it needs to hire an independent counsel. Just write a regulation that DOJ will continue to use independent counsels, and it'll be fine. And one of the lawyers they hired to write the regulation is named John Roberts. So if this comes before the court, and John Roberts has got to decide on this, it's going to be tough for him to say the analysis he did in 1999 is now obsolete. So despite longstanding precedents affirmed by many courts higher than Judge Cannon, she uses lifeline Thomas tossed to Trump to delay and perhaps end the case. So what's going to happen here? Well, first of all, this is really consistent with everything else Cannon has done. She was appointed, she's 43. She was appointed 3 years ago. She has very little experience. And before this last action, here's what was being said about her by legal experts, that Her handling the case is shaky. She worked very slow. She held hearings on all kinds of motions. Either she's ignorant of how to handle these matters in case she doesn't belong on the bench. If she's lazy, she doesn't belong on the bench. If she's doing it to just delay the case, she doesn't belong on the bench. She doesn't belong on the bench at all, no matter what she's doing. And now that she picked up Justice Thomas's lifeline to toss the case, it's pretty clear that she's auditioning for a seat on the high court. And, if Trump is elected and there's an opening, he may well reward her for helping him like this. So it's pretty clear what the right-wing Supreme Court wants. Now, Jack Smith has already appealed. And precedent says the lower courts will reinstate the case because these laws have been upheld over and over and over again. So then it'll get appealed to SCOTUS. It certainly won't be held this year. It won't be figured out till after the election. And if Biden wins, SCOTUS will hear the appeal. Maybe they'll overturn it. Maybe the Chief Justice will uphold what he wrote in 1999. If Trump wins, it'll never be heard because Trump's DOJ will drop the case entirely. And I've heard that dropping the case entirely might leave Judge Cannon's decision as a damaging precedent. I'm not quite clear on that because the appeals court probably will have overturned it by that time. So, but I did hear that and I wanted to mention it. So anyway, this is what you see from the SCOTUS that Trump built, clearing the way for Trump's return, or at least to keep him out of jail. And all the while, they're seriously damaging our democracy. What do all these rulings have in common? They're not just ruling on whether the law is being implemented properly. They're not just ruling on the constitutionality of the law. They're deciding policy for us. They're overturning long-standing precedent. They're doing things that Congress should be doing. They're saying Congress may not enable the administration to enforce security laws. Statute of limitations may not be specified by Congress. Congress can't enable the administration to determine regulations. Congress can't do all these things because SCOTUS is going to do them instead. SCOTUS can create Second Amendment rights that the founders never intended. SCOTUS can specify that we may not regulate weapons more stringently than our forebears did. And all that is just throwing our society, our lower courts into turmoil. SCOTUS has decided it would be a bad idea to allow states to implement our Constitution. SCOTUS has decided it would be a bad idea to have the president be liable to our laws. SCOTUS has decided that there should be immunity, even though there's nothing in the Constitution that says it. SCOTUS is overstepping the roles we laid out for them initially. Their roles are supposed to be making sure the laws are implemented properly and make sure the laws don't violate our Constitution. Their role is not supposed to be deciding things that are outside our Constitution, deciding things that the Constitution even calls for. That's the Congress administration. If they want to challenge what the Constitution says, Congress should pass a law, and we'll see if it stands up to constitutional examination. But they're overturning long-standing precedents. They're reaching beyond the present issues to find other things they can bring up. The things they're bringing up have very broad policy implications, broader than they probably understand. And the fact that the things they're doing affects other parts of the government, reshaping federal power, avoiding established judicial practice. This is the most activist court we've ever had, and it's way beyond their bounds of what they're supposed to do. A lot of these decisions just are not supported by our Constitution. There's nothing in the Constitution that says that Congress can't enable the administration to clarify their laws. There's nothing in the Constitution that provides presidential power immunities. There's nothing in the Constitution that changes our government this greatly. These changes are as big as the ones that came from the New Deal. And those changes came from Congress, not from the judiciary. And their decisions are based on their policy preferences rather than constitutional interpretation. These actions show that the court is taking on a more active role in shaping policy rather than limiting itself to their constitutional role. They're way overstepping their bounds. Congress is supposed to set our policies. The administration is supposed to implement the policies Congress has mandated. The judiciary is just supposed to make sure we do it fairly, don't violate our Constitution. SCOTUS is not just ensuring our laws are properly enforced, not just ensuring they don't violate the Constitution. SCOTUS has taken upon themselves to set our policies for us as they see fit, overriding Congress, overriding the administration. And there's been a lot of internal dissent, more internal dissent that you see in the decisions that we've ever seen before. Very sharp disagreements between the judges, unusual abundance of separate opinions. There's 6-3 split along ideological lines all the time. There's very vocal dissent from liberal justices, very strong language in dissent, creating a law-free zone around the president, and pushback from Roberts, which is unheard of, accusing the liberals of striking a tone of chilling doom. There's real significant internal dissension out of the court now, more than we've ever seen. And there's confusion in the lower courts is rampant. It's not just Bruin. Dobbs' decision has led to confusion in lower courts, school district decisions, student administration decisions. There's one about web designers refusing service for same-sex weddings. There's one about EPA's authority to regulate greenhouse gases. All of these decisions have thrown our lower courts into turmoil. They've led to not only confusion, but challenges coming from lower courts. When you talk about loss of respect, there's loss of respect from the public, historic low public opinion, continued decline. Partisan divides are perceived everywhere. Concerns about politicization. There's institutional distrust, and the impact of these decisions has been very controversial. But it's not just loss of respect amongst the public. It's loss of respect even among lower courts. New York Supreme Court has expressed dissatisfaction with what the Supreme Court is, the U.S. Supreme Court is doing. The Massachusetts Supreme Court has called out SCOTUS as being out of step with the times. Maryland Court of Appeals, the Illinois Supreme Court, the Oregon Supreme Court. These Supreme Courts are telling the federal Supreme Court, you don't know what you're doing. There's a growing trend of state Supreme Courts expressing the difficulty, the frustration, the implicit criticism of the U.S. Supreme Court's decisions, not just Bruin, but many like that. In fact, Hawaii Supreme Court said it all. Hawaii had a ruling recently that said, we don't agree with the Supreme Court's reading of our U.S. Constitution. We hold there is no state constitutional right to carry a firearm. You can't just look at history. History is prone to misuse. The court has distorted, cherry-picked historical evidence. It shrinks, alters, and discards other historical facts that don't fit its desires. So the Hawaii Supreme Court says judges aren't historians. Figuring out 18th and 19th century experience to figure out what we should do today is not a judge's role. History is messy. It's not straightforward. It's not fair. It's not made by most. It's not democratic. Bruin, McDonald, Heller, other cases show how the court handpicks history, makes its own rules. This is the Hawaii Supreme Court speaking back to the federal court. We believe that it's a misplaced view to think that today's public safety laws must look like the laws passed long ago. This quote and all the other quotes from other state Supreme Courts is criticizing of the Supreme Court for the way they're interpreting our laws and constitutions. You might even say that Roberts and Alito are gaslighting us. What does gaslighting mean? Gaslighting means it's psychological manipulation. It involves trying to make people doubt their own perception of reality. And so the court kind of basically says, nothing to see here. This is not a big deal. Don't worry about this. Chief Justice Roberts has mocked the three liberal dissenters for striking a tone of chilling doom, whereas in reality, the immunity ruling gives the president carte blanche to break criminal laws. During arguments, let's see, Justice Alito dismissed the government's concern. Nobody's suggesting that woman is not an individual. She doesn't deserve. But the reality is that that's precisely what the Idaho ruling by the Supreme Court suggested. The Chief Justice, again, writing for the court, upholding federal law that prohibits domestic uses for fishing guns. The Federal Appeals Court has struck down the law as unconstitutional. So And Roberts says some courts have misunderstood the methodology of our recent Second Amendment case, explaining the lower courts have been wrong. But the truth is that lower courts were following the letter of the Supreme Court ruling from 2 years ago. So you might call that gaslighting. It's just they're making excuses. Bottom line, they're not just judging, they're making new policies. They have enormous impact on our country in ways that scholars didn't intend, didn't expect, making excuses, blaming us for worrying too much, blaming us for misunderstanding. Then they try to clarify. They still leave a mess there, and they're allowing their right-wing zeal to damage our country. And what can we do? Congress can do a lot. Congress could limit the jurisdiction over several types of cases. They could alter the size of the court. They could expand it and add some more justices. They could require a supermajority to strike down a congressional law or to overturn a precedent instead of just letting a majority do it. Congress could do that. Congress could propose constitutional amendments to override court decisions. There are constitutional limits to the court. The Constitution itself could be used to limit the court, deciding only actual cases, actual controversies, not going far afield and laying out new things. They don't have to grant judicial review of laws. That's not in the Constitution. Congress could do these things. The president himself could do some things. Well, the president can nominate justices. The president could also enforce or not enforce court decisions. That's kind of a risky course to take. I wouldn't recommend that. But public opinion, public pressure, not a formal check, but it has pressure. The court could implement some of their own restraint, not likely. State governments can resist federal court decisions. You're seeing a lot of that happening now. The system of checks and balances isn't perfect, but in order for these kinds of things to be effective, we need a political will to use them. We need the voters to require them. And that means that all y'all have to support congressional action to reform the court. You have to insist that Congress do this stuff. You have to insist that Congress increase transparent accountability and challenge court rulings through the legal system. We have to engage in political processes and advocate for structural reforms. I happened to be a delegate to the League of Women Voters Convention in D.C. A couple of weeks ago. And what the League of Women Voters national leadership said is, we appreciate all you do out in the field to run a fair election. But what we do here is we file lawsuits. We find somebody that's doing something that violates our Constitution, we'll bring a lawsuit. So that's the kind of organization you want to support. There's a lot of organizations like that. American Constitutional Society, American Civil Liberties Union. There's the Supreme Court Institute. There's the Akron Law of Center on Constitutional Law. There's Drake Constitutional Law. We can support these organizations by donating, by volunteering, spreading awareness about them. But most of all, we have to participate in politics. We have to pressure our legislatures. We have to support candidates that will push back against this stuff. We have to support that at the state level as well. State courts push back. Vote for candidates up and down the line that will help rein in the Supreme Court. And here's some very late breaking news. Biden has just decided to add SCOTUS reform to his platform. He's had some recent discussions with the Congressional Progressive Caucus where he said, I'm going to need your help on the Supreme Court because I'm going to announce that I'm going to come out with a major initiative on limiting the court. He's been working with constitutional scholars for 3 months now. He needs political help to make this happen. He's talking about term limits for justices, which we can do without an amendment. He's talking about an enforceable ethics code. He's talking about constitutional amendments that reverse some of these serious mistakes the court is making. None of this stuff will pass the GOP-controlled House, but if we can get control of the House, then we can pass some of this stuff. Most importantly of all, this serves as messaging so that we help build political will for these kind of things. And elevating Supreme Court to his second-term agenda is an important part of his agenda. As usual, I got a ton of references in here. We'll send all these slides out. You can look at all the references I looked at in putting this presentation together, and I'm done and ready to take questions. That was a lot very quickly. And I'll send the slides out so you have a chance to read this stuff yourselves. I'm gonna kill the screen sharing, and we're gonna see who has got questions or comments that we want to talk about.
Yeah, not a whole lot of questions at this point, but I'm sure as we start the discussion, there will be. First, Ken Olson had a question about the Chevron decision. Ken, do you want to talk about your bring up your question?
It would seem like both Congress and the courts lack the expertise that's needed for this. One of the things that I work with is trying to make members of Congress aware of third-party expertise that we encourage them to use in developing regulations as well as the laws that they pass. It seems like this is going to be a more critical role, but how do we move something like that? Or is Google going to become the de facto third-party experts?
No. Right now, the expertise in these areas lives in the administration, in the regulating agencies. I mean, some people might argue that the right thing to do now is to try and move that expertise into Congress, which I think is the wrong thing to do. I don't think that you can have this expertise spread out through 100 senators and umpty-ump representatives on their staffs. I think it needs to be concentrated in a small number of staff. So, I mean, you could create a Congressional Office of Technology or something where you essentially move all the expertise that we have in administration into some congressional office that advises Congress. I don't think that's what's going to happen. I think it's going to happen is that we're going to keep the expertise where it is in the administration. And when somebody challenges, as they're now unable to do, the court is going to have a hearing, and they're going to bring administrative experts from the administration into the hearing, and they're going to bring in the experts that the opposing people bring in and make a ruling. I don't think it's reasonable to expect us to move all that expertise into Congress. So maybe that'll happen over time, but
yeah,
it's certainly not going to happen soon.
There is some expertise in the congressional staff, but not all the expertise exists in the agencies either. I work quite a bit in the genetics area, some in the environment and things like that. There's a lot of very good experts there that we seek to make available to really give us rules, regulations that are consistent with what the research shows. I think we need to find a way to do that. They're going to be more critical than what they've been in the past because they've had the agencies that could interpret things. But like, you know, personally, I've worked with some of the folks from the Animal Health Inspection Service in doing evaluations of programs in Mexico is where I work. But they called in teams of us from outside of the agency to bring in expertise that was needed to do it.
So you're saying, what you're saying is that the regulating agencies can bring in outside expertise to help form the regulations that make sense based on the science and the experience. But what we have, what the court seems to say is that doesn't fairly represent people who disagree with those experts. So now it sounds like the court wants these experts to come into court and to be rebutted by supposed experts that dislike this kind of regulation, and for the court to be involved in deciding whether we just adopt what the scientific expertise is into our regulations, or whether we dispute that through a judicial process. I think that's what's going to happen here.
Yeah. I think.
Okay. Well, thanks for your
in Congress. The continuity, you lose the continuity because they're up for election. The House every 2 years.
Well, there can be congressional offices that are apolitical. You know, like the OMB, the OMB, the Office of Management Budget is there are congressional offices that Congress creates that are staffed with expertise that serve every Congress, no matter who's running it, who's in the majority. Congress could build an office like that. But in any case, what the judiciary has said here is that if there's any ambiguity, it can't just be the administration seeking out expertise or having internal expertise to clarify the best course that Congress intended. It's got to be done in a judicial process where other people can dispute that. Ken, thanks for your input on this. I'm glad to have your input. I'm just telling you how I think this is going to go down.
Yeah,
Okay, thanks, Ken.
Yeah, next one is Denise Stoneback had a couple of comments. One about the something that it was the Judiciary Act of 2023. Denise, you want to explain that?
Sure. Yeah. This is an initiative of Newtown Action Alliance, and they have an action alert going to try to encourage people to reach out to their senators and representatives in support of the Judiciary Act, which would increase the number of justices on the Supreme Court. And I'd love your opinion on this. I do trust this organization. I'm familiar with it. And then on a separate note, I did drop in the chat Brady's statement on the Bruin decision, which I'm so glad that you brought up. I mean, it's set us back so far. And the Dobbs decision, I dropped in a link from the League of Women Voters, which has, again, set us back just years, decades on women's rights. But would love to hear your opinion if you're familiar with this idea of increasing the number of justices on the Supreme Court and how that might help do damage control in what we're experiencing.
Well, of course, yes, I'm very familiar with this. I've discussed this several times in the past in prior presentations. Expanding the court, but in of itself, is not really all that useful. But in this situation, where the right has used raw political power to attack the court with extreme right-wing justices who are violating the spirit of the court and exercising unreviewable power to reshape our government, expanding the court to implement additional left-leaning judges who will restore some balance to the court. When there was some balance to the court, and a guy like Roberts, who's not extremely right, could cast a deciding vote, things were not as bad as they are right now. So if we expanded the court, even just by 2 judges, and filled those seats with left-leaning judges, we'd be in better shape. But we're not going to do it before the election. And unless Biden wins, expanding the court would be a bad idea, because then you get more right-leaning judges instead of left-leaning judges. But this is something Congress can do. There's no doubt that Congress can do it. And what I heard recently from Biden is that he's not specifically recommending that. He is recommending term limits. Enforceable ethics could help almost as much as expanding the court, because enforceable ethics might cause a couple of justices to have to recuse themselves from the decisions. And that might put Roberts back in a swing vote role that could bring forth some decisions that aren't quite so badly biased to the right. I understand why Biden's not pushing for expansion, because expansion could become tit for tat. You do it, they do it. And expansion is not useful if the other side wins. But a code of ethics could have a similar impact if it is a way to ensure that people are forced to recuse themselves when necessary.
That's great. Yes, I certainly support a code of ethics and believe that it's necessary. So really powerful. Could be. Yes.
Well, thanks for your links in the other area. We're in thorough agreement that the Dobbs decision, the Bruin decision, are giant steps backwards for our country, and that we need to find a way to overcome them. He's looking at the possibility of amendments in these areas, although I think the most important areas where we need amendments are in the issues of presidential immunity and the likes. Okay, what else we got, Jim?
Yeah, just so there's a lot of links in the chat. So if everybody wants to copy those or save them for to view later, just go down to the bottom and you can copy the chat.
And when we send the slides out, we send the chat as well. So you'll get those links as part of what's coming to you after the presentation. Go ahead, Jim.
Yeah, so Loretta Jackson had a comment and Loretta, I don't know, maybe you want to talk a little bit about something about Alita and Thomas, if they resign or are removed, would Judge Cannon. Loretta, do you want to talk about that?
Well, I think it's clear that Judge Cannon's intent here is to ingratiate herself to Trump and the right-wing MAGA groups such that she could join their forces someday. If Trump wins, and if some senior judge chooses to retire, she might be a candidate. I mean, she doesn't really have the legal background to qualify herself for such, but Trump might not care about that. Trump might just say, this woman saved my ass, so I'm going to put her in. Yeah, but I don't think that neither of those guys are going to be removed. I mean, those guys are only going to leave when they want to leave. There's motions that have been filed to impeach them, but that's not going to work. The GOP in the Senate is not going to remove a right-leaning.
The critical thing is to maintain control of the Senate, because then a judge can't come on without being approved by the Senate. So if we maintain the Senate, even if Trump were to win, he couldn't appoint these judges.
I agree with that, but maintaining the Senate is, frankly, unlikely. We have a much better chance of holding the House than we do holding the Senate. So, in my view, the presidency is the key here, not the Senate. We can work. We're working. I'm sure the Democratic Party is doing all they can to hold the Senate, but I think it's more likely for us to hold the presidency than to hold the Senate.
So Veronica has a question. Veronica, you want to unmute and ask your question?
Well, thank you. I was actually raising my hand on behalf of Liz, who put in the chat that she has a question but doesn't know how to raise her hand. So,
okay.
Oh, thank you so much. I really appreciate it. I'm new to this group, but I actually have a long history of working in the government. I worked at OMB. That's where I started.
Great.
I'm sorry. I'm going to be a flamethrower. I appreciate what you've said tonight. I know these people. I started at my first job at OMB in the White House, in the Reagan White House, when I was 23 years old. I know these people. I saw this start. These guys, mostly guys, will stop at nothing. We're having a very interesting, intellectual, really rich discussion tonight, and it doesn't mean a lot because they are going to take down, they've already took down the government. I work at EPA. What they're going to do is throw us into complete chaos. And we have this sort of Damocles of climate change hanging over us. We don't have a second to wait, much less what they've just done. So I would argue that we have to kind of throw away the old model of politeness and taking our time and getting the Senate back and the House back. This is absolutely an existential, hair on fire, immediate crisis. If I were Biden right now, I would be using the immunity that Roberts just gave us. And by the way, I disagree that he is going to turn back. He is now the YOLO right-winger. I knew him a little bit. Started almost at the same time. He has been working for years to have the unitary executive and to put into effect his racist and misogynistic policies. He's not going back to center. He feels completely unburdened now. So to me, we have a couple of months with their decision of complete immunity. We still have the presidency. I think absolutely expanding the court under an emergency executive order is really the only chance we have. Because even if Biden ekes out a win, you can be sure that there's some kind of fake elector that's going to come up. It's going to be thrown to SCOTUS, and they're going to throw the election to Trump. So we have about 4 months? 4 months to really take this seriously, because it's not just a normal existential crisis like we had with Bush v. Gore. As I said before, we have no time to wait for climate change. So I'll shut up, but I do think we need a new model. I don't know what that is.
So Liz, you're suggesting that. Thank you for your input. I appreciate the viewpoint your experience brings us. But did I hear you say that you think that Biden can expand the court unilaterally? That's something the Congress has to do, isn't it?
He can do an executive order.
An executive order to change the size of.
It would only last until the end of his presidency, but it might be enough to prevent the throwing. I am not a lawyer. I'm not an expert on this, but the court just handed extraordinary immunity powers to the president. Yep. They know full well. Republicans use power. Democrats don't know how to use power. They're afraid to use power. So we have the only chance that I see is for Biden to seize that what SCOTUS just gave them and figure out a way to expand the court. Forget term limits, forget ethics. Republicans laugh at us. They laugh at us. And they expected this. And they're going to do whatever they're taking down the whole administrative state. If Trump wins, I fully expect to be fired on day one.
Yep. But any unilateral order by Biden to expand the court would surely be challenged in the court, and SCOTUS would shoot it down as being
who knows? I mean, that's the ultimate question, right? Who are they? The ultimate divine authority on everything? I mean, that's my question. Is there anything that can happen without, what if Congress passed a law saying that they had to expand the court? Would SCOTUS step in and say, unconstitutional? That's my question. Can they ever
understand?
Can they ever be stopped? And I would argue, can you imagine if a Republican president were in place right now and everything was flipped? Do you think for a second they would hesitate to seize this power? And they would not. They would not. And that's why I'm saying I'm being a flamethrower. We cannot play the game as we've been playing it the last 40 years. They're doing trench warfare, and we are being polite and playing by the rules. And because the livelihood of the planet literally is at stake, I would argue we need to seize power.
I take your point. I'm not sure that unilaterally expand the court is the right step at this point. I do take your point that if they've given the presidency expanded power, it would be in our favor to use that expanded power somehow to stave off Project 2025 and all that it entails. Thank you for your comments. I really appreciate it.
Thank you.
Okay.
Yeah, so Denise has her hand up. So go ahead, Denise.
Thank you. I just want to reiterate, Liz, I agree. I think we should explore every option, and I would love to see the Biden administration take hold of the latest Supreme Court decision and implement everything they can. We're in an emergency situation here. And so everything within the Biden administration's power to restore democracy should be explored. So that's all I have to say.
I'll give you an example. In our neighbor to the north, Wisconsin, the GOP legislature, when the Democrats won the governorship, the GOP legislature changed a whole bunch of laws and policies just before the new Democratic governor took office, which limited his power and attempted to minimize what he could do in office. Maybe the right thing to do is for the president to issue a bunch of executive orders which would stymie the new administration and do it in such a manner that they can't easily be rolled back. That might be one of the approaches. But the thing that bugs me is that I'm not sure I see how the issue of immunity helps that. I mean, what could Biden do that's considered illegal that would help us other than jailing Trump or in some manner? It's not clear to me how the immunity ruling helps. But I do agree that we should play hardball as hard as we can.
So
anything else, Jim?
One more question. Can SCOTUS implement Project 2025? Carrie, was that your question?
When you look at what's in Project 2025, what it amounts to is shifting all power to the presidency and allowing the presidency to unilaterally implement a long wish list of right-wing policies, decisions. Now, I think it's wrong to say that SCOTUS could implement those things. And if the purpose of Project 2025 is to concentrate power in the presidency, well, that's not what SCOTUS has been doing. What SCOTUS has been doing is concentrating power in SCOTUS, not in the presidency. And SCOTUS could implement some of the things that are in Project 2025, just the way they've implemented presidential immunity and curtailed the 14th Amendment, yada, yada, yada. But the whole point of Project 2025 is to dismantle the protections we have in place, that we put in place after Watergate, the protections you put in place to limit the president's power and stop presidential abuse of power. So SCOTUS could help with that by declaring some of these limitations on presidential power as being, SCOTUS could help by making some of the same policy decisions that Project 2025 asks the president to make, and I wouldn't put it past him. But the bulk of Project 2025 is intended to be implemented by the president and not the Supreme Court. I'd have to go back and look in detail to suggest some of their proposed policies and see which ones would be easily implemented by the Supreme Court unilaterally. Generally, Supreme Court has to have a case brought up and make a decision based on some case that's been brought up before they can change policy. And that can take 2 or 3 years. So the GOP wants to act, Trump wants to act faster than that. He wants to hit the ground running day one and start implementing these policies immediately. So I don't think SCOTUS can do that, for example.
Yeah, Ed, one last question from Lana May. She wants to get active. What can we do?
Okay. On the political front, we need to get active at the presidential level in Wisconsin, Michigan, and Pennsylvania. We must win those 3 states. You can reach out to the Democratic parties in Wisconsin, in Michigan, in Pennsylvania, and just ask them how you can help. You can help if you want to travel to a neighboring state. You can help with canvassing. You can help with voter registration. You can help from your home in letter writing and postcard writing. You can make donations to these organizations. At the lower level, you need to be politically active in supporting the candidates up and down the ballot that will support our democracy, and just generally means supporting Democrats up and down the ballot, or progressive candidates up and down the ballot. Work for the local progressive candidates, especially if you're in a purple neighborhood, like a suburb, where the suburb might actually swing to a Republican candidate. We have a good chance of capturing the House. We might be, and we can work in our state to help do that. We might be able to withhold the Senate. You need to find the Senate seats that are in doubt and see if you can work for them or make donations to them. Let's see. I mentioned a number of organizations that you can support that will continue to file lawsuits and bring things before the court to defend our democracy. You'll get the slides, and there were some organizations mentioned there. And come back to talk to Bill about the people we know that you can help in the current political environment. Bill or Jim, do you have anything else you want to add in those areas?
Yeah, and both the Indivisible Alliance of Chicago and Indivisible Evanston are running weekly busloads of people, carloads of people, up to Wisconsin to knock on doors, to canvass, to help in any ways. They also are doing registration there. Indivisible Alliance of Chicago, which is an alliance of all Chicago chapters within Chicagoland area. They're going not only to Wisconsin, but they're going to Michigan. They've really got their feet on the ground in these areas. And then really simple things, like those are big. And now we're just kicking in to doing phone banking within Indivisible Illinois, picking up candidates to do phone banking. These are more localized elections, but just anything that we can do to help out. This is going to be a social media war. And if you're on X, Threads, Instagram, we're doing a lot of farming. Our organization does it with Field Team 6 every Tuesday and Thursday at 1 p.m. for an hour. And then every other Friday with the Truth Brigade, create truth sandwiches to send out and then to amplify. So just almost anything you can think of, people can do.
Bill can hook you up with people. The other thing I'll say is that I am happy to reproduce this discussion for any group you can find that cares to hear about it. A church group, a Rotary, a League of Women Voters chapter, any group of 5 or more warm bodies that care about our democracy. You let me know, and I'll show up, and even in person if necessary, and spread this gospel. Because as was said here, this is really damn important. The presidency and holding the House are the 2 things we got to do. We got to do those things, or we're going to have a real problem.
Yeah, let me clarify. If you've never done postcarding, they come in packs of 25. You get a list of people in the state that are targeted, and you get a short message to write on that postcard. So you don't have to come up with what you want to write on the postcard. It's just you're copying, and it's already been decided. So it's very simple. You just have to handwrite it.
And then put a stamp on it.
Yeah.
But it's effective because it's one person talking to another. It's one concerned citizen talking to another citizen who can help make the right choice for our nation. These things do help, even though it's a small effort on your part. If you can't come up on a weekend and canvas, you can certainly write some postcards or some letters. Those things help. If you can throw in a few bucks here and there, that helps too. That's where we're at. Anything else in the chat, Jim?
No, that's it, pretty much.
Okay. Well, I'm going to give you guys 10 minutes of your life back then, because we're 10 minutes early, which is amazing. So thank you all for coming.